Thank you, Madam Speaker. I rise in opposition to this amendment to H.R. 8. And this amendment is another example of pro-corporate, anti-environmental legislation designed by large corporations to restrict access to the courts for the average citizen. The Gosar Amendment ignores separation of powers by telling the federal courts how to do their job, restricting the type of relief a court can grant, and penalizing successful challenges under the Equal Access to Justice Act. This in turn limits access to legal relief for those challenging government decisions. Now, let's say you're a farmer or a rancher or a landowner and you live adjacent to federal land that is being leased out to an energy company for fracking. And you're worried about what's going to happen to your drinking water. You're worried about the price of your house, and you're worried about the health of your children. Well, this amendment will greatly interfere with your ability to challenge the decision of the federal agency granting the permit. It'll tie the hands of the courts in terms of deciding the case in a fair and just way. For nearly 70 years, the Administrative Procedure Act, or APA, has served as the foundation for administrative agency action. It ensures that agency action taking place in the rulemaking process is fair, efficient, and flexible enough to accommodate the myriad of agency actions it governs, along with the challenges of daily life. Judicial review of agency action is a hallmark of the APA, and it's critical to ensuring that government action does not harm or adversely affect the public. The Gosar Amendment would discard decades of wisdom and jurisprudence preserving the right of judicial review. First, it would reduce the statute of limitations for judicial review of agency action under the APA to 90 days. This is down from 6 years for most claims brought against the United States in cases involving onshore and offshore energy leasing, development, and transmission on federal lands. This razor-thin window for review would effectively immunize government action involving energy projects from public accountability, allowing those agencies to opt out of our civil justice system. Second, the amendment limits a judicial stay of final agency action by requiring courts to only consider whether relief would be the least intrusive or narrowly drawn relief possible to correct a violation. Courts, however, typically consider other things, such as where the public interest lies. This sweeping limitation would dramatically interfere with the court's ability to provide relief, tilting the outcome against the public interest. Lastly, this amendment slams the door to the courthouse by prohibiting access to funds under the Equal Access to Justice Act. By enacting the Equal Access to Justice Act, Congress recognized that individuals and organizations should not be deterred from challenging unjustified governmental action simply because it costs too much. For three decades, veterans, seniors, persons with disabilities, small businesses, and nonprofit organizations from across the ideological spectrum have relied upon the Equal Access to Justice Act to challenge illegal government action. This amendment would cripple the rights of those concerned or opposed to an energy project by preventing those who cannot afford to litigate a case against a big corporation from recovering fees, expenses, and court costs when they win. It's time for this Congress to stand up for everyday Americans, and I would urge my colleagues to stand for the rights of the individual and local communities and oppose this misguided amendment, and I'll reserve the